How to fill out my wholesale purchase agreement for virtual wholesaling real estate. When I first started wholesaling, I had no idea what I was doing. And like you, I was searching the internet endlessly trying to find a contract because the mentor I had at the time didn't provide one. After almost an hour of digging, I finally found what I was looking for. But it was a 15-page state-approved contract that realtors used. There was just one problem. I wasn't a realtor, and I had no idea what half of it even meant. Even worse, I didn't know how to even explain it to a seller. Now, here's the crazy part. Even though I didn't have much information, I did have confidence. And because of that, I still got my first deal under contract. But I don't want it to be that hard for you. I don't want you spending hours searching. I don't want you confused by legal language. And I don't want you hesitating and missing deals because you're unsure. So that's why I made this video. So today, I'm going to walk you through my simple one-page wholesale purchase agreement line by line so you know exactly what it means and how to explain it confidently to your seller. Now, before we jump in, I'm not a real estate attorney. This is not legal advice, and everything in this video is strictly for information and educational purposes. If you need legal guidance, please consult with an attorney in your state. Let's get into it. Now, before we walk through it, you can download this exact contract for free. Just scroll down in the description and under resources, go ahead and click that link. It'll take you to a page like this where you can enter your name, phone number, and email, and it'll send the agreement right over to you. Once you click free instant access, it'll bring you here. Click download, and it'll bring you to the agreement right here. Simple. Let's walk through it. Now, you want to pay attention because one small section here can either protect you or cost you a deal if you don't understand it. So let's start with the date field. This just establishes when the agreement starts. Simple. But the date also starts your inspection clock and closing timeline, and timing matters. Next, we have our buyer and seller fields. Buyer, that's you or your LLC. Seller, that's whoever owns the property. It's really important that you get this field accurate because if multiple people own it and one doesn't sign, you don't have a deal. So to prevent losing deals, make sure that this information is clear and you verify ownership, whether it's in public records or on a software like Deal Machine or PropStream. Next, let's go to the property address. This just identifies the property. Keep it accurate. A small mistake here can create unnecessary headaches later. Let's go down to the purchase price. Buyer agrees to purchase and seller agrees to sell the above property for the sum of blank. So this is the number you agreed upon with the seller. When explaining this to a seller, just keep it simple. This is the price that we agreed to. Don't overcomplicate it. Everything else in your deal flows from this number. Now let's go down to the earnest money field. Earnest money to be held in escrow and the amount of blank. This is your deposit. It shows you're serious. In wholesaling, it's often small, usually around $100, and it goes to the title company or closing attorney, not directly to the seller. And then it says at closing, buyer shall pay the balance in cash. So this is the amount that our cash buyer is going to pay, right? So he is going to be paying the purchase price in cash. Now here's something important. Earnest money doesn't make the deal legitimate. The contract does. The deposit just reinforces it and does what's called bind the agreement. Next, let's go down to the closing date. Closing shall take place on the date that is typically the closing date. We like to set 30 days from today's date, right? And then here it's going to be at whatever title company or closing attorney that you're going to be closing at. So again, the closing date sets your timeline, usually 14 to 30 days. There's also language allowing extensions if title issues come up. That protects you from delays outside of your control because delays do happen. Let's go to buyer possession. This is the date you're going to close. So buyer possession shall be by 5:00 p.m. on blank. If you're doing a 30-day inspection period, which we recommend, then you want to put the same date here as it would be 30 days from the start of signing the agreement. So if you put a 30-day inspection period, the end date of your inspection period is also going to be the date of closing. Now, one little thing we like to do here where it says on is put or before. So this gives you flexibility to be closed sooner if you'd like to close sooner. Inspection condition clause. This gives you time to inspect the property. So where it says condition, you're always going to select buyer's obligation to purchase the property is contingent on buyer's approval of its physical inspection of the property. Buyer shall have until 10:00 p.m. on blank date, that's the last date of your inspection period, to complete its inspection of the property and shall have access to the property for inspections. If buyer is not satisfied with the result of the inspections, buyer may terminate this agreement by notice to seller anytime before the date above. If buyer fails to give any such notice, this condition will be deemed satisfied or waived. So if for whatever reason you're not going to proceed with the contract, you just have to deliver written notice to the seller. Typically, that's an email. If you're not satisfied during this inspection window, you can cancel. Again, this is your safety net. This clause is what keeps wholesaling low risk. Most beginners don't realize how much protection this gives them. So if you understand this section, you remove a lot of fear. Let's go down to the next one. If the condition described above is satisfied or waived by the buyer and buyer does not close before the close of business on the closing date, buyer shall forfeit the earnest money deposit to seller as liquidated damages, and this agreement shall be of no further effect. Buyer will be free of any further obligations. If seller fails to complete the transaction, the earnest money will be refunded to buyer, but will not waive other remedies available to the buyer. Okay, what this basically states here, if you go past your inspection period, or if you click this waive checkbox right here, and you don't perform, you don't bring a buyer for this deal, and you don't close, then what happens is the seller gets to keep your deposit as liquidated damages. And that's it. That's the most they could go after you for, right? Which gives us a lot of peace of mind as wholesale. But if the seller doesn't perform and they default on closing, then what happens is this language gives you the ability to go after the seller if you need to for any type of legal fees or to get them to close. At the end of the day, we want to close transactions. We don't get paid unless we close, but this builds in a level of comfort for you because we can cancel the agreement without liability if, in fact, we need to cancel for whatever reason. Deed shall be conveyed to buyer at the closing date by warranty deed, free and clear of any liens or encumbrances. Real property taxes for the current tax year and other usual items shall be prorated as the possession date. Time is the essence regarding this agreement. This is basically saying once the property transfers from the current owner to the end buyer, it's going to be done so on the closing date by a warranty deed. This is the most common way and cleanest way to transfer ownership from one person to another, free and clear of any liens or encumbrances. A lien is just like a loan against the property, someone demanding money. So they placed a lien against the property that must be paid at closing. And an encumbrance is anything that prevents a property transferring from the current owner to the new buyer without clear title. Clear title just means there needs to be a clear chain of ownership going from one person to the next without any doubts in there of other people laying claim to the property. So real property taxes for the current tax year and other usual items will be prorated. So again, the taxes are prorated. The buyer is going to pay prorated taxes when he purchases the property. He's not going to pay taxes on the property when he didn't own it. It's only going to be from the point of owning it to the rest of the remainder of the year. So time is of the essence. Again, this is just making sure all parties understand this is urgent and we're all moving forward. Now, let's go to the as is clause. The property is being sold as is, okay? Seller represents and warrants to buyer that the sewer line is intact and in good working order, and seller knows of no material structural defects in the property except blank. The property is sold and purchased as is. All representations and warranties in this agreement shall survive at closing. Seller has accepted this agreement on seller's own determination of the property's value and has not relied on any representation of buyer regarding its value or marketability. So basically, the seller is understanding here and agreeing to that they are selling this property as is. The buyer, you and your cash buyer, are agreeing that you're going to be moving forward with the property as is. And outside of the inspection period, there's nothing else that's preventing you from moving forward, and you're not representing the seller or providing an assessment of value for them at all. They are making this decision solely based on the property being sold as is. Okay? You're buying its current condition. Remember, your inspection clause, again, gives you a lot of flexibility. So are you guys seeing how the pieces here work together? Now, seller represents the buyer. Let's go to the profit disclosure. Seller acknowledges that buyer is purchasing the above property in an attempt to make a profit. This states that the seller understands you're buying the property to make money. This protects you. Transparency builds confidence and prevents future misunderstandings, right? Okay, this next piece right here. This agreement is binding on seller, buyer, and their heirs, legal representatives, successors, and assign. In the event legal action is taken to enforce any term of this agreement, the prevailing party shall recover from the losing party reasonable attorney's fees incurred as set by the trial court and or appellate courts. Now, the seller cannot go after you if you don't perform on this agreement. Based on the language in our agreement, deposit is sole remedy. But this is if we are going to be going after the seller if they don't perform. This part also allows you to assign the contract. It mentions assigns right here. Without this language, wholesaling becomes much harder. You're not selling the house, you're selling your position in the contract, and that's the model. Okay? So to make this even more ironclad, when you sign your name down here, you want to put and/or assigns after your name. So you sign it and then type next to it and/or assigns. and then put the date. This agreement's binding on seller, buyer, and their heirs, legal representatives, successors, and assigns. We went over that. So this is where everything comes real. Once the agreement is signed and once your earnest money's on file with the title company or closing attorney, you now have what's called equitable interest in the property. That means you have the legal right to purchase it. Because you have that right, you can now market your contract to a buyer, not the house, the contract. You're not selling the property, you're selling your contractual position, and that is wholesaling. Simple, clean, and powerful. So now you have a simple purchase agreement, a clear understanding of how it works, and the confidence to use it. But a contract doesn't matter if you don't have sellers signing it. So if you haven't started generating leads yet, watch the next video on the screen right now. That video will show you how to start contacting motivated sellers so you can actually put this contract to use. So if this helps you, all I ask is go ahead and like the video, subscribe to the channel, and download the free contract below, and I'll see you in the next one.